At 22-2 here on 5AA, Sarah Game is a One Nation MP in State Parliament's Upper House and joins you now. Good afternoon, Sarah Game.
Thanks so much, Stacey.
Appreciate your time today. We want to talk about your ICAC legislation in just a moment, but I thought I might ask you about the Child Protection Bill, or the proposed amendments to the Children and Young People's legislation that was released yesterday. I know you wanted to have a look at the legislation properly before you gave a response. I'm wondering if you've had a chance to turn your mind to it and what your initial thoughts on the bill are.
Yeah, thanks so much, Stacey. Look, it is 147 pages or so long, but there were a couple of things that I was on the lookout for, so I haven't had a thorough look, but certainly have a couple of points. I mean, one of the first things I did when I took on this role in Parliament was I met with Katrina Hilliard about establishing legislation to guarantee resourcing for the child and young person's visitor role. So the child and young person's visitor basically meets with and advocates for young people in residential care, so our most vulnerable people. When I met with the previous Guardian for Children and Young People, Penny Wright, she told me, look, when the Children and Young People Bill 2017 went through, there was a mistake and there was no legislation to say, look, this role needs to be adequately resourced. So I spoke to Katrina about that, a couple of years ago, and she said, look, wait, we're doing this review, let's not do it now. And so it actually received no support from the Labor Party. So I was anxiously awaiting to see whether there was now this new legislative requirement that this very important role would be resourced. I cannot see that, Stacey. Now, we are going to reach out to Katrina Hilliard and confirm that, but certainly it wasn't in the section of the legislation that you would expect. I've read coroner's reports where there's been the death of young people in residential care, where it's been stated very clearly that were that young person more frequently visited by an advocate, for which they are currently not resourced to do, that death may have been prevented. So that was one very disappointing outcome. Secondly, I have spoken to carers. Now, in the last couple of years, the number one complaint from carers, and if we're thinking about children and young people and what the answer to these neglected children is going to be, carers play a pivotal role. And it's been very distressing to hear that carers feel that when they make a complaint, that their child protection caseworker perhaps is not advocating in the way they see is in the best interest of the child that they're looking after. They're actually feeling as though there's some sort of witch hunt against them, and they are scared to advocate for the best interest of that child. So they've made it very, very clear that they want an independent complaints body, and they've been calling our office and spoken to me and said, look, we're totally unhappy with this. And that doesn't seem to be in the legislation adequately either. So at the moment, it's not looking good. But I haven't, as I say, looked at all 147 pages, but those 2 points are very disappointing.
Okay. Yeah, that was something we had spoken to Tammy Franks about yesterday as well, the independent complaints process or the complaints mechanism in there. So I might follow up on that one when we get some time next week. Thank you for reminding me about that. I also put to Tammy Franks and Connie Benares, both on the crossbench in the Upper House as well, alongside you. Yesterday there was a discussion, or that the three of you had said that when Parliament resumes, you would be supporting a censure motion into the Minister in State Parliament's Upper House. Tammy and Connie yesterday said they will no longer be supporting a censure motion because at least the legislation has now been introduced, which is what they were calling for. The opposition is still seeking for the censure motion to go ahead. Where do you sit on that?
Look, I wouldn't support it at the moment. I think at the moment, given the legislation has come out, it's just really a distraction. What I'm interested in now, that it's finally come through, is understanding from Katrine exactly what's happening with this independent complaints body and why this resourcing for the child and young person's visitor role hasn't been guaranteed.
Okay. Let's move on to your changes to the ICAC legislation, or proposed changes to the ICAC legislation. This is a really interesting one after, the announcement of a few weeks ago that Anne Vanstone would be standing down from that role. I know that the watering down of the ICAC legislation that happened in Parliament a few years ago preceded your time in Parliament, but it was pretty overwhelming. Every MP voted for the changes, and in my experience working down at Parliament House, I've never seen a piece of legislation pass so quickly. It was extraordinary, Sarah Game, how how supportive everybody was. You never see that sort of bipartisan support right across the political spectrum. So let's talk about the changes that you're proposing to make and whether or not you think they might have the support.
Well, I think you raised some really good points. I mean, what's interesting, I wasn't in Parliament when those changes were made, but I have tried to have a look at those amendments, and how anyone decided quickly that they were going to support them, I don't know. I mean, there's about 80 pages worth. So it's almost impossible to actually understand all of what's within those amendments that were passed. And there were certainly some very big failings. I've met with the outgoing ICAC commissioner, and she's explained to me clearly her very modest requirements, which I think would be very difficult to argue against, although apparently she had written to the Attorney General back in October requesting these changes and they haven't been made. So my piece of legislation that I'll be putting forward essentially does three things. One, it creates a new definition of corruption in public administration. So what happened was, before the changes in 2021, the definition was corruption in public administration is any offence committed in public administration. Now, I don't think we need to go back to that, but those amendments in 2021, they made the definition of corruption so narrow that things like theft and deception, even where theft and deception result in significant financial impact, are actually excluded from the definition of corruption in public administration. For me, that's not adequate.
Theft?
It's not adequate. It's just not adequate, Stacey. And so what the ICAC commissioner or outgoing ICAC commissioner wants, which is in fact the same as what was recommended by the Integrity Committee before the amendments went through, is that corruption in public administration should encompass any offence that is punishable by 2 years or more in prison. And I think that's very hard to argue with. I mean, if someone commits an act for which they can go to prison for 2 or more years, surely that was a corrupt act. So that's the first thing that this piece of legislation does. The second thing it would do, again, absolutely fundamental and basic, is it restores the ability for the ICAC commissioner to speak and communicate directly with the Director of Public Prosecutions. So currently, the ICAC commissioner will undergo an investigation. When I met with her in her office, she explained to me how thorough they can be, many, many folders spanning an entire room. Once she's conducted that investigation, instead of being able to speak directly with the Director of Prosecutions, this information has to sort of be shipped off, I don't know how, but, in a truck or something, off to the SAPOL, and SAPOL is then left to sift through this investigation and decide whether it should be directed to the Director of Public Prosecutions. I mean, one, that's a complete waste of time. It can delay the investigation by a year. It's a waste of taxpayer funds, and we're burdening SAPOL when really we need them to focus, back on their actual job of fighting crime and keeping people safe. So allowing the ICAC commissioner to communicate directly, I think it's very hard to argue against that. And the third piece...
Before you go on to number 3, Sarah Game, can I ask, is that something that you've spoken to SAPOL about? I can't remember having a discussion with Grant Stevens about that. Do you know if SAPOL would be supportive of that change?
I haven't spoken to SAPOL about that, but what I would say is, and the ICAC commissioner made clear to me, was that ICAC are the only public authority that are not able to communicate directly with the Director of Prosecutions, which makes no sense. And I would have thought, I would be interested in their view, but I guess one thing to consider is that some of those investigations conducted by ICAC, they could be about police officers. And so one could argue that really it's not appropriate to be sending an investigation about a police officer to the police for the police to decide whether that goes to the Director of Prosecutions or not. Okay. So I'd be very surprised if they wanted to take on that role. And also, I mean, the ICAC commissioner, she's been a judge in the district court, she's been a barrister and solicitor in the Supreme Court. You're dealing with an extremely experienced individual, and it doesn't seem to make any sense to me that after conducting the investigation, she's not able to speak to the Director of Prosecutions herself.
Yeah, and especially as you mentioned, given that the ICAC, the scope of the ICAC, at least it used to include looking into SAPOL and police officers. I think the first charges made by South Australia's ICAC, I remember being at the press conference, was the 6 police officers from in the southern suburbs. I think, is it the Mantle case? Now that
Look, it just makes no sense that SAPOL would be in charge of deciding whether or not this gets referred on at all. So that would be the second piece. And the third fundamental piece is really that if a corrupt act occurs or any act of material adverse effect, that public servant or that politician is not able to claim reimbursement from public funds for their legal fees.
I can't believe that's not in the legislation already. So someone can be charged, convicted, and then still claim money back for their legal costs?
You can still, at the moment, the problem is that the definition of corruption is so narrow that the only way really to ensure that the legal fees can't be claimed back, my understanding, is if they were in fact investigated by ICAC under the heading of corruption. But because, as I said, we've narrowed that definition of corruption so much, including excluding theft and deception, we now have the possibility that, yes, someone could have committed an act and then claim their legal fees off the public purse, which makes no sense to me.
No, and I'm sure it wouldn't make sense to much of the voting public either. I'm just trying to imagine an MP or someone in public office being convicted of a theft or deception and then being able to claim their legal fees back, especially after they're convicted. They're found guilty. Then they can claim their legal fees back. That makes no sense. No one else in the state would be afforded that right.
They're so basic and obvious, aren't they, Stacey, that when I really looked into this and I sat down with the Commissioner, I couldn't believe that these basic requests hadn't already been met, as I say. And I think there will be some support. I know that some of my crossbench members, and certainly, David Spears, when he was the Leader of the Opposition, expressed some openness to reviewing this. So I'll be introducing my piece of legislation the first week back. And I do hope that the door is open to revisit this piece of legislation.
Okay, well, we'll stay in touch and see how that goes. Parliament's back, in a fortnight? So
that's right.
Not too long to wait. Have you
Thanks so much, Stacey.
I know he's only new to the job, but given you've had some positive indications from the former Liberal leader, have you had a chance to touch base with the new Liberal leader, Vincent Tazier, about it?
Well, I haven't, but look, I have, as soon as it was announced that Vincent would be the new leader of the opposition, I reached out and got his phone number. We've had a few text exchanges and ironically, just before this interview, he did text me and ask whether I was free to chat today. So I'm hoping that we'll be able to have a positive relationship, and certainly I'll be sitting down with him and discussing this piece of legislation and other ideas that I have too.
Yeah. And any word from the government yet? Have you sought their opinion on the legislation yet?
No, look, I haven't, Stacey. I will do, but I think they've dug themselves a little bit of, I think they've just dug themselves a little bit of a hole. I do not know how they're going to be able to justify not rectifying these certain issues. I think we cannot hide behind, yes, perhaps there were certain changes that need to be made, but certainly there's no justification for not including theft and deception as a corrupt act. There's no justification for not allowing the ICAC Commissioner to speak to the Director of Public Prosecutions. And there's certainly no justification that if a public servant or politician commits an amoral, unethical act of any material effect, that they can be charging the public for their legal fees.
Yeah, yep. I think it would be a pretty easy decision to make, but I was surprised at how easy the decision to make to change the legislation was. As I mentioned, I've never seen anything quite like it in my time at Parliament House.
80 pages, Stacey, 80 pages. How anyone got their head around quickly around 80 pages of amendments, I have no idea.
Yep. I know, and it went through so quickly. I remember I was reporting that night and I was watching Parliament, and it passed so quickly that I had to go back and rewatch it 2 or 3 times to say, did that just pass? It was a matter of minutes that it passed through both houses, and I've never seen anything like it. It was quite extraordinary, that's for sure. So we'll wait and see how these changes go in a fortnight's time when Parliament's back. Sarah Game, thank you so much for your time.
Thanks so much, Stacey.
Upper House One Nation MP there, Sarah Game. What do you make of the changes? Do you think that a politician should be allowed to be charged with theft or deception under the definition of corruption? And do you support the change? I'm pretty sure this will be a really easy one to answer. The change to say if someone, an MP or anyone in public office, the ICAC investigates anyone in public office, not just MPs, anyone who's a public servant, do you support the idea that if they are convicted of a theft or deception, that they should not be able to claim their legal fees back? I would have thought that that is pretty stock standard, not being able to claim your legal fees back if you've been found guilty of an offence. I think it's pretty extraordinary that that can still happen. In no other world, in no other profession, there's no other person in the state that would be able to get their legal fees back from the taxpayer if they're found guilty of a theft or deception. So why should a public servant who's been found guilty and convicted? That just makes no sense to me, but that's me. I'd love to hear your thoughts. 8223 0000 is the number to call, or you can send me a text 0448 08 1395. After